Morning, namaste, namaskar, assalamu alaikum, vanakkam. Friends, in this class, we will be discussing decree, judgment, and order in the light of the Code of Civil Procedure. Friends, this is very helpful for the judiciary aspirants. The concept of decree, judgment, and order has been asked in many examinations in both preliminary examination, that is screening test, as well as in descriptive test. Friends, is my audio and video clear? Am I visible to you? Okay. Okay. Friends, today's concept is decree, judgment, and order as per the Code of Civil Procedure. Okay. Now, let us discuss the concept of decree first. Okay. Thereafter, the order and judgment. Okay. First, decree. Friends, if we go through section 2, subsection 2 of CPC, section 2, subsection 2 of Civil Procedure Code, this section defines the word decree. Now, see the plain meaning of the word decree, friends. See the meaning. Okay. The entire words have to be written here. Decree means the formal expression of first we need to write the entire definition of the word decree. Thereafter, we will very elaborately discuss every key point involved in this definition. Decree means the formal expression of an adjudication, which so far as regards the court expressing it conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit and maybe either preliminary or final. It shall be deemed to be include rejection of plaint and determination of any question okay, within the ambit of section 144 of CPC, but shall not include any application from which an appeal lies, okay, as an appeal from an order. Or any order for dismissal for default. Dismissal for default. Very elaborate definition. Very elaborate. Now, based upon the entire definition given under section 2, subsection 2 of CPC, it is better to catch the important points here. Okay. Now, decree means it is a formal expression. It is formal expression of whom? It is formal expression of the court. What is the form of this formal expression? It is in the form of an adjudication. Who expresses it? It expressed by the court. Then how it expresses it? Then it conclusively determines rights of the parties. Whether it determines only one right or all the rights, okay, it may determine all or any of the matters, okay, any of the matters in the controversy, whether it is applicable to a particular all the applications. No, this is applicable to goods and only few applications. Okay, whether it is final, no, it may be preliminary or final. Okay, here deemed to be include, this is one part, okay, and not include, this is the another part. Thus, these are the important words involved in the definition of the word decree, friends. Okay, these are the key terms. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties. Okay, so far as, that is so far as, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in suit, and may be either preliminary or final. It shall be deemed to be include rejection of plaint and determination of any question within section 144 of CPC, but shall not include any application from which an appeal lies, as an appeal from an order or any order for dismissal for default. Therefore, friends, there are, if we analyze this definition, we can find 4 parts in the definition of the decree. Okay, There are four parts. Now let us see the four parts of decree. About decree. Section 2, subsection 2 of CPC. Analysis of the definition of decree. Friends, we can find four parts. Part 1. Part 1 is related to the basic definition. Part 2 is related to inclusive definition. Part 3 is related to exclusive definition. Part 4 is related to types of decrees. Now, friends, if we see this one, decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in suit. Okay, this is the basic definition given for the word decree. If we see the second part, that is inclusive definition. It shall be deemed to be include rejection of plaint and determination of any question within section 144. This is one part. This is second part. Okay, this is inclusive definition. Okay, deemed decree. This part is related to deemed decree. Okay, next if we see this one, but shall not include any application from which an appeal lies as an appeal from an order or any order for dismissal for default. Shall not include. This part is the excluding definition or exclusive definition. Here this part very clearly excludes any application from which an appeal lies as an appeal from an order. Appeal from an order has been excluded from the definition of decree. It is very expressly stated in the definition itself. Therefore, it come under the purview of the exclusive definition. And any order for dismissal for default is also not included in the definition of the decree. Therefore, it comes under the purview of exclusive definition. If we see the part 4 here, may be either preliminary or final. It means that there may be there are two types of decrees: preliminary decree and final decree. Therefore, based on the definition given for the word decree, there are four important parts. Okay, the basic part or the basic definition is that decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in suit. Okay, this is the basic definition. Then there is a inclusive definition. Here the definition itself comprises of this inclusive definition. It shall be deemed to be include rejection of plaint and determination of any question within section 144 CPC. It is the inclusive definition. Thereafter, there is a part 3. Part 3 speaks about the exclusive definition. it speaks that shall not include any application from which an appeal lies as an appeal from an order, or any order for dismissal for default shall not come under the purview of decree. It is exclusive definition. There is a fourth part. It says about types of decrees. It may be either preliminary or final. Thus, these are the important parts involved in the word decree, friends. Now, let us see the basic ingredients. Okay, the first part or basic definition. Here, the basic definition part use the meaning and elements of decree. Okay, it is speaking about meaning and elements of decree. Okay, meaning and elements of decree. Meaning and elements of decree. Okay, here let us see the important concepts here. Okay, under this category, decree means a formal expression of an adjudication. It is a formal expression of an adjudication. Okay, this is the first part. The second one is, here this adjudication must be given in a suit. Okay, adjudication must be given in a suit. Then this adjudication must determine the rights of the parties with regard to all or any of the matters in controversy in the suit. Okay, therefore it is a determination of rights of the parties with regard to all or any matter in controversy in suit. Okay, then here this determination must be conclusive in nature, must be conclusive in nature. Okay, then the fifth point, a decree may be preliminary or this comes under the purview of, okay, this come under the purview of types of decrees. Now let us see the formal expression of an adjudication. The formal expression of an adjudication, friends, the formal expression of an adjudication here, the word to constitute a decree In order to constitute a decree, friends, okay, the dispute must have been settled by means of an adjudication. Here, the word adjudication literally means that to settle the dispute judicially. Okay, to settle the dispute judicially, it is the meaning of the word adjudication. Okay, it must be settled through judicially by a judicial authority. It means that adjudication means judicial adjudication. Therefore, adjudication means a judicial adjudication. It must be decided by a judge. It must be decided by a court. Okay, it is the meaning. Then such adjudication must be given in a suit. In order to constitute a decree, friends, the adjudication or the judicial determination must have been given in a suit instituted by the aggrieved party, instituted by the plaintiff. Here, friends, the counterclaim, okay, the counterclaim and the set off, okay, they're also treated as the separate suits. Therefore, the word aggrieved party is very suitable instead of using the word plaintiff. Therefore, the judicial determination must have been given in a suit instituted by an aggrieved party. Here, the word suit means, friends, a case filed or an action instituted before the court of competent jurisdiction seeking the protection of one's own right, friends. Okay, or in order to determine the dispute involved in between the aggrieved party and the opposite parties, in order to determine the actual dispute involved in between the plaintiff or plaintiffs and defendant or defendants. Therefore, it is not defined in the court of civil procedure, but in AIR, okay, in this case law, in All India Reporter 1933 PC 63, okay, 64, 60, 1A 13. In this one, it is Hansraj versus Dehradun Mussoorie Electric Transways Company Limited. In this case, it was held that the word suit originally means, and apart from some context, must be given to mean a civil proceeding instituted by the presentation of a plaint. Okay, whether there is no civil suit, then there is no decree. This was the principle laid down in this case, friends. The word suit has been explained in this case law as to in this way. Okay, that is, a suit means a civil proceeding instituted by presentation of a plaint. Okay, once a plaint has been presented by the plaintiff, if the plaint is presented in accordance with the rules of the pleadings, in accordance with the civil rules of practice, and if it is filed within the period of limitation, and the full court fee is also paid, and all the essentials has fulfilled, then the suit will be numbered, sorry, the plaint will be numbered, and the plaint becomes a original suit, friends. Okay, therefore suit means a civil proceeding instituted by the presentation of a plaint, but the word suit is not at all defined in CPC. Therefore, it is the meaning of adjudication in a suit, friends. Adjudication in a suit. Adjudication means the judicial determination, or adjudication means to settle the dispute judicially or by judicial authority. Okay, now these 2 points are come. Okay, now these two, it's okay. Now it is also okay. Now, determination of rights of the parties with regard to all or any of the matter in controversy in suit. Here, determination of rights of the parties in controversy is a very important concept under a decree. Friends, to constitute a decree, there must be an adjudication. Here, the adjudication must be in a given suit. Then, this determination of rights of the parties in respect of the matters in controversy, it is the important one. Here, the word right denotes the substantive rights, friends, and not the procedural rights. Okay, here the word right, any right, rights of the parties. Here, it is a substantive right, but not the procedural right. Therefore, if a party have any substantial right, then such substantial right may be determined, should be determined by the judicial authority through its decree. Friends, here the word party refers to parties to the suit, whether he may be the plaintiff or defendant, or in case a claimant has been included, even a third party who is included himself as a party, then once he becomes a party to the suit, then he is also becomes a party to the suit. Okay, he may be included as a proposed defendant or proposed plaintiff. Once he become a plaintiff or defendant, then he is also regarded as party. Rights of the parties means parties to the suit, but not a general party. He is a party outside of a civil proceeding. Therefore, then one more word, controversy in the suit relates to the subject matter of the suit. All or any matter in controversy in the suit, it means that determination of the rights of the parties with regard to all or any of the issues involved in the suit. Okay, then such determination must be conclusive in nature. Okay, this is a conclusive determination, friends. To constitute a decree, the determination or the adjudication must be conclusive. Okay, it must be complete, friends, and it must be final with regards to the court which passed a decree. Therefore, it must conclusively determines the rights of the parties. Once the rights of the parties are conclusively determined, then it is said to be a decree. If the rights of the parties are not conclusively determined, then it cannot be said to be a decree, friends. For instance, there are two parties, Mr. A and Mr. B. Okay, there is a dispute in between Mr. A and Mr. B. Now, Mr. A has instituted a suit before a court. Okay, he has filed a suit before the court of law. Then the court has this is a case against Mr. B. Okay, he has filed the suit against Mr. B. Now, A has filed the suit against Mr. B for permanent injunction, for perpetual injunction. Okay, I am the owner of this particular building. Okay, I am the owner of this building. Okay, this building belongs to me. Then I have acquired the right, title and possession over the vacant site from Mr. X, who is my vendor. I have paid full consideration or legal consideration amount to Mr. X, who is my vendor. Thereafter, I have acquired the right, title and possession over the vacant site. Subsequently, I have constructed a building therein. Okay, I have constructed this building with a prior approval from the municipal authorities. Okay, my name is also mutated in the municipal authorities records with regard to this house. Okay, I have been paying the property tax, water tax, etc. with regard to this house. Okay. Now, without having no manner of right, Mr. B, who is none other than one of the neighbors on the left side, has been on and off disturbing my peaceful position and enjoyment over this building. Okay, his action is high-handed. He came to my building on 1st October 2021 with his men, and he seriously tried to dispossess me from the building, but I have prevented his high-handed action with the aid of some other neighbors. Okay, he left the premises, but while he lefting the premises, he clearly stated that while he leaving the premises, he very clearly warned that he will come again with sufficient men and money to forcefully dispossess me at any point of time. Okay? He has full muscle power and money power. He may come at any point of time and he may forcefully dispossess me from my own house, over which I have full title, possession, enjoyment. Okay. Therefore, his high-handed action should be prevented by the Honorable Court. Hence, I am instituting the present suit for the relief of perpetual injunction against Mr. B, okay, to restrain Mr. B from interfering my peaceful possession and enjoyment over this building, the suit schedule mentioned building, okay, by way of a permanent injunction, okay, in the interest of justice. This might be the averments of Mr. A while he is filing a suit. Here, the court, if the court wants to give the final determination of the rights of the parties, if the court wants to determine Mr. A's rights conclusively, it takes a long time, friends. Okay, it takes a long time. Oh, okay. In order to prevent the immediate high-handed action of Mr. B, Mr. A can file an interlocutory application. Okay? He can file an interlocutory application. Here, if Mr. A files an interlocutory application for an ad interim injunction, okay, for an ad interim injunction, it means that, okay, he may come at any point of time. Therefore, the Honorable Court may please it to pass an ad interim injunction by dispensing with notice to Mr. B, to the respondent defendant, and the Honorable Court may be pleased to pass, okay, an ad interim injunction restraining Mr. B from interfering my peaceful possession and enjoyment over the same. Okay, if he sought for ad interim injunction, okay, in absence of Mr. B, the court will pass an order. Okay, it is not the conclusive determination, just it is a preventive measure to prevent the high-handed action of Mr. B. Therefore, it cannot come under the purview of decree, friends. Here, the court is not conclusively determining the rights of Mr. A, whether Mr. A has any right to get a perpetual injunction decree against Mr. B. It is not conclusively determined, just based upon the averments given in his petition, which is filed under Order 39, Rule 1 and 2. Okay, based on the facts stated in his affidavit, the court may pass an ad interim injunction if Mr. A files an interlocutory application. Here, it does not mean that it is the conclusive determination of the rights of Mr. A. No, it is not the conclusive determination. If B comes with sufficient material, if Mr. B comes with any documents, sufficient documents, in order to prove his case, then he may immediately file a counter. Thereafter, an inquiry will be commenced. The court will hear both the parties. Then it may pass an order. Okay, this is entirely different. Okay, if both the parties adduce their evidences, okay, the plaintiff himself came before the court, came before the witness box, and he himself deposed as a witness, Thereafter, he has produced several evidences, several witnesses. He has also produced several documents. Then, after conclusion of, after closing of his evidence, okay, Mr. B may also produce his evidences, his witnesses. Thereafter, an argument will be initiated by both the counsels. Finally, a decree will be passed by the court. It is a conclusive determination. After a full-fledged trial, after examination in chief of all the witnesses, after their cross-examination, after the re-examination, if any, then okay, then after arguments, after hearing both the parties, if the court conclusively determines the rights of the parties, it becomes a decree, friends. If the court, without conclusively determining the rights of the parties, passes any order, it cannot be treated as a decree at all. Therefore, it is a conclusive determination of the matter. It is a conclusive determination in nature. Okay, it is about the basic definition, friends. Basic definition. Now, based upon this part, we can say the meaning and elements of a decree. Okay, it is a formal expression of the court. It is a judicial determination of the court. Okay, the court adjudication means the judicial determination of a judicial determination by a court. Okay, it must be given in a suit, but not in any other proceedings. Okay, it must be given in a suit. Okay, then the determination of it must determine the rights of the parties, friends, with regard to any one of the matter or all the matters, any one of the issues or all the issues which are in controversy in the suit. Okay, the next essential element under the basic definition of the word decree is such determination must be conclusive in nature but not temporary in nature. Okay, this is about it does not mean it is interim in nature. It must be conclusive in nature. This is over, friends. This part is over. Now, inclusive definition. Let us see the inclusive definition, part 2. Part 2 is dealing with inclusive definition. Okay. Inclusive definition. Let us see what come under the purview of inclusive definition. The inclusive definition means that it is a deemed decree. Deemed decree. Friends, if we see the definition part, okay, it shall be deemed to be include rejection of plaint and determination of any question within section 144 CPC. Deemed to be include, it means that it is a deemed decree, friends. It is a deemed decree. It very clearly expressly stated that these are also included within the meaning of the word decree. Therefore, now let us see deemed decree. Here the two following items are included in the definition of the word, okay, decree. These two are treated as deemed decrees, friends. The first one is rejection of plaint. Rejection of plaint. The second one is that determination of any question in determination of any question in section 144 of CPC. Here it means that if any order has been passed by the court, if an interlocutory application is filed by the opposite party under Order 7, Rule 11 of CPC, or if the court summatorily on the basis of Order 7 and Rule 11 of CPC rejects the plaints, it amounts to a deemed decree, friends. It amounts to a deemed decree. If the court determines any question in section 144 of CPC, it means that an application filed for restitution. Okay, here the determination of any question under section 144, that is for restitution, is also come under the purview of the inclusive definition. Here it is not a play, it does not amount to a suit, friends. Within the suit there are interim proceedings. Within this interim or interlocutory proceedings, if an interim order has been passed by the court in an application filed by the opposite party for rejection of the plaint, or if the court with its suo motu power rejects the plaint under order 7 rule 11 of CPC, then it is also deemed to be a decree, even though it is not passed in the main suit. Okay, it is also deemed to be a decree. The determination of any question with regard to the restitution of the restitution of the possession, etc., under section 144 of CPC is also deemed to be a decree, friends. It is also an application is filed for a restitution of the possession and etc. under section 144. Therefore, it does not mean it is a main suit proceeding. It is a just interlocutory proceeding, or interim proceedings. The rejection of the plaint is not a main suit proceeding. It is a interim or interlocutory proceeding. Therefore, even though any right of the party is determined, or if the court adjudicates any matter or all the matters involved in any application filed under order 7 rule 11, or any application filed under section 144 of CPC, the order passed by the court in these two applications can also be deemed to be a decree, friends. It is the meaning of the word inclusive definition. It is the meaning of the word inclusive definition. Okay, Ekam Singh ji, now is it visible properly? Ekam ji, I'm very sorry. I'm very sorry. I am not very fluent in Hindi. Okay, I'm not very fluent in Hindi. Hello, Ekam ji. Utkarsh ji, good morning. Good morning. Pranjal Kumar ji, good morning. Pranjal Kumar ji, good morning. Okay, bold pen. Is there any option for this one? Okay, there is no such option here. Okay. Good morning. Good morning, Anil Dixit ji. Good morning. Very good morning. Very good morning. Very good morning. Therefore, in these two cases, the decision of the court is generally an order, friends. It is an order, but not a decree. However, part 2 of the word decree, the part 2 of the definition given for the word decree, these two, the orders passed by the court in these two applications shall also be deemed to be a decree, friends. Deemed to be the decrees. Okay, deemed to be the decrees. Therefore, this is about part 2, friends. However, in order to facilitate the aggrieved party to prefer an appeal, okay, they are brought under the definition of the word decree. Okay, hence the deemed decrees, friends. These two are deemed decrees. Now let us see the other important points here, especially the exclusive definition. Okay, the exclusive definition, part 3. The exclusive definition. Birendra Murmuji, good morning. Exclusive definition. Friends, here 2 points are come under this one. The first one is an appeal from an order. Okay, the two items are excluded from the definition of the decree. there are any adjudication from which okay, from which an appeal lies, any adjudication here, any adjudication from which an appeal lies, okay, as an appeal from an order. And the second one, any order for dismissal for default, any order for dismissal for default shall not come under the purview of the word decree, friends. Here, appeal from an order, any adjudication, okay, any adjudication from which an appeal lies as an order, it means that if there is an appeal, an appeal is available from an order. Here, any order is passed for dismissal for default in absence of if the plaintiff fails to appear before the honorable court, then the court may dismiss the suit for his default. The court may call the plaintiff called and absent, no representation from the plaintiff side. Therefore, the suit is dismissed for default. Whenever a direction has been given by the court for appearance of the plaintiff, the person who files a particular suit, if he fails to appear before the honorable court, even though a particular direction has been given, a particular condition has been imposed by the honorable court, if he fails to fulfill that condition, if he fails to appear before the honorable court, whenever a particular an express condition, express direction has been given by the court, then he fails to appear before the court, then the suit will be dismissed for default. Then if any adjudication from which an appeal lies, okay, any adjudication, it means that in case of any interlocutory applications, okay, in case of any interlocutory application, if an order has been passed by the court, if the aggrieved party has one more opportunity to file an appeal before the appellate authorities, then it cannot be treated as the decree, friends. It cannot be treated as a decree. Or any order for dismissal for default cannot be treated as a decree. Okay, this is about part 3, friends. Part 3 of this one. Okay, next, part 4. Part 4 is dealing with types of decrees. Part 4 is dealing with the types of decrees, friends. The types of decrees. Okay, under this one, if we see the definition part, okay, any controversy in the suit, it may be either preliminary or final. Okay, now let us see here. Preliminary decree, and final decree. Okay, good morning Birendra Barmuji, Mamruji, good morning. Preliminary decree or final decree, or partly preliminary or partly final, also come under the purview of types of decrees. Now let us see the concept of preliminary decree. Concept of preliminary decree. Friends, here the preliminary decree means that where an adjudication decides the rights of the parties with regard to all or any of the matters in controversy in the suit, but does not completely dispose of the suit. Okay, dispose of the suit will be a preliminary decree, friends. In case of a suit for partition, okay, a suit for partition, not very bright. And a suit for partition or in a suit for foreclosure of mortgage, okay, and a suit filed for preemption, okay, okay, suit filed by one of the parties for a dissolution of a partnership firm, okay, or then a suit for foreclosure, suit for redemption, suit for sale of mortgage property, etc. and etc. also come under the purview of this one. In all these suits, here in a suit for partition or in a suit for partition, here there are two sons and two daughters, okay, A, B are the sons, friends, C and D are the daughters. To one Mr. X and Mrs. Y, okay, they are the parents. Now Mrs. Y died in the year 2010. X recently died in 2020, okay. Mr. A is the elder son, Mr. B is the younger son, C and D are the daughters to X and Y. Now there are several properties in the name of Mr. X, okay. There is a building, there are some agricultural properties or agricultural lands, okay, there are some house sites, okay, there are some house sites in the name of Mr. X, okay, all these are related to Mr. X only. Now after the death of Mr. X, Mr. A and B, the sons, have been mutating their names in all the revenue records, in all municipal records with regard to these buildings, agricultural lands or house sites, and whenever C and D, their sisters, here A and B, C and D are their sisters. Whenever C and D have been requesting them for division of these properties as per the metes and bounds, then A and B have been rejecting their proposal, rejecting the proposal of their sisters. Thereafter, they became very adverse to the interest of C and D. A and B now have been stating that C and D have no right, even they cannot get even a single penny, even a single paisa from the building, agriculture lands or house sites which are acquired by their father during their lifetime. Okay, being the sons, they they only have the right over the property. That is their version. Okay, daughters have no right at all according to their version. But the daughters here, their sisters, it means that daughters of Mr. X and Mrs. Y, they have been requesting their brothers to divide the property as per the meets and bounds, but they did not heed the words of their sisters. A and B are not heeding the words of their sisters. Okay, now as a last resort, C and D have filed a suit for partition to divide the entire properties, the building, agriculture land, house sites, into 4 parts or 4 shares, and allot each share to C and D. Okay, 1 share to C and 1 share to D. They have filed a suit for partition. The Honorable Court may be pleased to pass a preliminary decree to allot 2 of such shares to the plaintiffs. 1 share is for first plaintiff, another share is for second plaintiff, by way of a preliminary decree, after considering the good and bad qualities. After considering the good and bad qualities of the properties, it is then the court may, after conducting a full-fledged trial, the court may determines the rights of the parties. Then the court may pass a preliminary decree that C and D are entitled for each share. Okay, the plaintiffs are entitled 2 shares out of 4 shares. First plaintiff is entitled for 1 share. Second plaintiff is entitled for 1 share. Okay, it is the preliminary decree. This preliminary decree has been passed by the Honorable Court in a particular suit. Then it is the conclusive determination of the rights of the parties, but it is not the completion of the suit proceedings, friends. It is not the completion of the suit proceedings. After passing a preliminary decree, after determining the rights of Mrs. C and Mrs. D, they have to file an interlocutory application under Order 20, Rule 18 of CPC for a final decree, friends. They have to file an application, an interlocutory application for a final decree for appointment of an advocate commissioner to divide the entire property as per the meets and bounds. Then the court, after considering the report of the advocate commissioner, then it will divide the properties physically and allot and put the plaintiffs in their respective shares. The court will put the plaintiffs over the position of their respective shares, friends. This is a final decree. Okay, the first part is related to preliminary decree, the second part is related to a final decree. In the first part, in the preliminary decree, the rights of the parties are determined in case of a suit for partition. Then if they file an application under Order 20, Rule 18 of CPC for final decree, then an advocate commissioner will be appointed. Then he will divide the properties as per meets and bounds after considering the good and bad qualities into account. Then based upon the report filed by the advocate commissioner, after considering the objections, if any, filed by both the parties, then the court will pass a final decree and the court will put the parties in their separate position over their respective shares. Okay, this is the final decree, friends. Similarly, in a suit for mortgage, suit for preemption, suit for dissolution of partnership, a preliminary decree will be passed. Finally, a final decree will be passed. This is not an exhaustive. List, friends. There are a number of suits. There are different types of suits wherein a preliminary decree will be passed. Thereafter, a final decree will be passed. But in majority of the suits, only one decree will be passed. At the end, it conclusively determines the rights of the parties. In case of suit for permanent injunction, in case of suit for a declaration, in case of suit for a specific relief, okay, for specific performance of a contract, in a suit for in a case of suit filed for cancellation of an instrument, in case of a suit filed for a negative declaration to declare so and so as not the legally wedded wife of me, okay, so declare so and so as not legally wedded wife of so and so. In these cases, in these kind of suits, in case of a suit filed for recovery of money based on a promissory note, in a suit filed for recovery of promissory note based on a based on a check, okay, if a suit is filed for recovery of money based on some transactions, financial transactions, in all these cases, okay, in all these cases, friends, a final decree will be passed. Only one decree will be passed. In these, for instance, in these suits, initially a preliminary decree will be passed, and finally a final decree will be passed, friends. Thus, this is about types of decrees. Now we have studied all these points. Okay, basic definition is the first part, inclusive definition is the second part, exclusive definition is the third part, and types of decrees is the fourth part. I think we have discussed all the points with regard to decree, judgment, and order, and an order. No, sorry, with regard to the concept of decree. Now, friends, let us see the concept of okay, the concept of judgment. Okay, the concept of judgment. Friends, section 2 subsection 9 of CPC defines the word judgment. Okay, judgment means the statement given by the judge on the grounds of a decree or order. Now we have not discussed the concept of order now. Okay, judgment means the statement given by a judge. It is a statement. It is given by the judge. Here it is based upon the grounds of a decree or an order. Okay, it is given by the judge on the grounds of a decree or an order. Now let us see the essential elements, friends. Now let us see the essential elements. Okay. Essential elements of a judgment. If we see these essential elements, now it is a judgment is a statement, friends. It is a statement. Okay, this statement must be, such statement must be given by the judge. Must be given by the judge. Okay, then the statement of the judge must be based on a decree or an order. Friends, if you see the concept of judgment, the judgment speaks about the evidences produced by the parties. Okay, the reasons for giving such kind of order or a decree. Here it includes the brief averments of the plaintiff, the brief averments of or the version of the plaintiff, the version of the defendant. Then based upon these two versions, what are the issues framed by the court? Then after framing of the issues, what who are the witnesses, okay, came before the honorable court in order to depose their evidences. Okay, then the list of witnesses, the list of documents filed by each parties. Okay, exhibit A1, A2, A3. Okay, the the list of exhibits exhibits filed by the plaintiff, exhibit B1, B2, B3, etc. The list of exhibits filed by the defendant side. Okay, the court exhibits, the documents of the court, the exhibit C1, C2, C3, the exhibits of the third party, exhibit X1, X2, X3. Thus, the version of the plaintiff, the version of the defendant, the issues framed by the court, then the list of witnesses from both the sides, then the list of documents filed by both the sides. Okay, thereafter the reasons for determination of the issues. Okay, why a decree has been passed in favor of a plaintiff, why the suit has been dismissed against the plaintiff. Here the grounds for the judgment. Okay, this is not the evidence, it is not admissible in the evidence, the plaintiff failed to show his right, the plaintiff fails to determine his right, the plaintiff fails to show his right before the honorable court, therefore the suit is dismissed. Okay, the plaintiff, he has shown, has proved these facts. Okay, on the basis of these so and so witnesses, the statements given by so and so witnesses, the statements, the documents filed by the plaintiff, which is marked as so and so. These grounds are well discussed in the judgment. Based upon these evidences, based upon these statements given by the witnesses, I come to the conclusion and to pass this and pass this decree based upon these these facts. That kind of explanation will be given in the judgment. Here the judgment cannot say about what are the contents of the decree. Friends, generally e-court's website, if you go through e-court's website, you will find the judgments. Okay, the judgments of the decided cases, but the decree copy cannot be available in e-court's website in majority of the states. Friends, once if you observe the decree as well as the judgment, decree is the summarization of the entire case. Okay, it simply speaks about the name of the court. Okay, the cause title, name of the plaintiff, name of the defendant, and the main relief, for what relief plaintiff has filed this suit. Then when they have adduced their arguments, then what is the decision of the court, how the court conclusively determined the right of the parties, along with how much, okay, how much right the plaintiff is entitled, okay, along with the cost of the suit, etc., will be written just in two or three pages. The decree will be written by the honorable judge. Okay, but the judgment is a elaborative discussion of all the facts, all the witnesses, all the evidences. Okay, it also discusses the version of the plaintiff, version of the defendant, issues. The court will answer every issue involved in the case. Therefore, it is an elaborate discussion of all the points. Friends, the judgment also quotes several reported decisions of the Supreme Court, High Court if necessity arises. Then it is elaborate discussion of all the facts. Judgment, friends. It may be in number of pages. Okay, but if you see any decree, it may be within 2 or 3 pages. Okay. Now, these are the essential elements of a decree. If you see the concept of order, the word order has been defined under section 2 subsection 14, friends. Section 2 subsection 14 determines the concept of defines the concept of order. Order means, okay, order means the formal expression the formal expression of any decision of a civil court which is not a decree. which is not a decree. Okay, other than decree, any formal expression of any decision of a civil court is said to be an order. Simply, friends, simply see the difference. In a suit, a decree will be passed. Within a suit, there will be some interlocutory applications are filed. The court will pass an order. Okay. Other than decree, all these are orders, friends. A few orders are appealable, few orders are not appealable. Especially any order passed by the honorable court under Order 7, Rule 11. If an interlocutory application is filed by the defendant for rejection of the plaint, it is deemed to be a decree. Actually, it is an order, but it is deemed to be a decree. Or if any order has been passed by the honorable court, if an interlocutory application is filed by the either party to the suit under section 144, it is also an order, but it is deemed to be a decree. Rest of all of them, all the decisions, formal decisions expressed by the civil court or the order, friends, only finally if the court conclusively determines the rights of the parties in a suit, it becomes a decree. Okay, I think you got the point, friends. If time permits me, I will differentiate the concept of decree and order in some other class. Okay, the key differences, only the differences between order and judgment in the next class. Thank you very much, friends. Thank you. Goodbye.